don't go crazy when the judge says your claimant had a good day, when things look hazy, 'cause there's nothing left of 25A. Don't get angry, get mad today. We're gonna help you through it all, 'cause you, my friends, are beautiful. We're gonna get you through it all the way.
Okay, hi. Welcome to Lawyers and Friends. As you would have heard if you were in the room here with us, this is our regularly scheduled episode of Lawyers and Friends, and I'm your hostess today, Melissa Day, and this is my friend, or reasonable facsimile of a friend. His name is James Cousins.
Hi.
My partner. And today we're going to talk about, because it's this time of the year, Thanksgiving is coming up. It was also just my birthday, and there are, of course, December holidays and end of the year, beginning of the year holidays. It always reminds me of holidays that our friends, our clients, enjoy as a result of recovery from a third-party action. And in addition to those, you also get a lien recovery to benefit from that as well, so we're going to talk about that. Before I do that, I'd just like to turn it over to James for a second to do our regular disclaimers.
So today's presentation is for educational purposes only and doesn't constitute legal advice, although there are two pretty brilliant lawyers, also very humble ones, the most humble you'll ever meet, on the screen today.
This was better the first time around.
It was. Nothing herein constitutes the creation of an attorney-client relationship, although many, if not most of you, are already our clients. And past results do not guarantee future outcomes. And so with that, we'll start with the education.
Excellent. So third-party actions. In order to talk about third-party actions, we have to go back a little bit to the origins of the workers' compensation law in New York and really throughout the country. And one of the statutes that's relevant to third parties in the comp law is that compensation is limited when an employee is injured at their employer to workers' compensation under the statute. And this is a result of a grand bargain that was struck between labor and business, in that employees gave up the right to be able to sue their employer for essentially enjoying benefits as a result of injuries sustained at work on a no-fault basis. And this is referred to as the grand bargain. Slide. There are exceptions to the exclusivity rule for workers' compensation. One of those is an intentional tort. So if James and I grabbed Najee, our wonderful producer, who is always being great at being able to juggle our video, our audio, he records this, and he sends out our invites. But if, say, for example, we were annoyed because the audio didn't work on a particular day as a result of, during one of our webinars, and I intentionally walked over to Najee and I punched him in the nose, he would have a right, because that is an intentional tort, to sue me instead of being limited to his remedy for workers' compensation. In addition to intentional torts, when an employer fails to secure workers' compensation coverage in some manner, either by self-insuring or by purchasing an insurance policy, then they've essentially failed to hold up their end of the bargain, the grand bargain. And because they have failed to secure coverage, an employee also can elect to sue their employee directly, or their employer directly. Slide. James, why don't you take this one?
Well, this is one of my favorite points I like to make whenever I talk about Section 29, which is if you have an injury that occurs at work and there is a tortfeasor other than the employer or a co-employee that's involved, that is to say there's somebody who caused or brought about the injury, you can sue the tortfeasor. I just like saying tortfeasor. I'm going to see how many times I can say tortfeasor during this presentation.
If you're at home and your employer allows you to drink at lunch, why don't you drink every time he says it?
Tortfeasor. All right, drinking game, tortfeasor. So you can sue that tortfeasor, and you can do so, but only under the auspices of Section 29. And it's something that third-party lawyers, negligence lawyers, forget often. They forget that this is a cause of action that arises under Section 29. And whenever I talk to any lawyer, I just tell them, if you can just remember that this is a cause of action under Section 29, you will save yourself a lot of heartache and potentially malpractice. The statute specifically says that if the injured employee is entitled to compensation under this chapter, let's say they have a comp injury, but there's a negligence or wrong of another, the tortfeasor, take another shot, under the same employee, such injured employee need not elect whether the compensation and medical come under the chapter or pursue the remedy against that other person. They can do both.
So prior to discussing Section 29, we were talking about the employee and the employer's rights and responsibility vis-a-vis one another. This Section 29 addresses the employee's rights vis-a-vis a tortfeasor or somebody who has done wrong to them who is not in the same employ. Very important that they not be the same employee, because that would make them an employer and then they would be limited.
Great, perfect example, motor vehicle accident. They're driving for work. Joe Schmo off the street rear ends them. Doesn't work for them. There is a tortfeasor. It's the other driver. And they have a comp claim because they were injured in the scope and course of their employment.
Okay, you know you shouldn't be drinking every time you say tortfeasor, right?
No.
Slide.
Section 10. This presentation is solely occasioned by my intoxication.
When an employee has a cause of action against a tortfeasor not in the same employ, the employer is subrogated to the employee's right to bring an action. So under Workers' Comp Law, Section 29, subsection 2, the employer can step into the shoes of the employee and bring an action on the employee's behalf if the employee has not commenced an action within a certain period of time. The section itself is pretty technical on how to commence that action and to notify the plaintiff that you're going to be taking over the action or pursuing one on their behalf. And there are time limitations for when you can do that. But you should know that the employer does step into the employee's shoes to bring an action in the event that the employee doesn't bring an action.
There's also some really highly technical case law about subsequent intervention. When they start a suit, they move along, and all of a sudden, plaintiff's counsel is not being super cooperative, or wants us to reduce a lien, or wants to settle a case, or doesn't want to sue a case, and we may not want that, so we can threaten intervention too.
That's a great move, because frequently the plaintiff's attorneys become less enamored with the cause of action when they're faced with the challenges of actually having to potentially sue the case or to take the case to trial than when they first sign up the claimant, because of the size of our lien, and that can make it so that the claimant's not, or plaintiff is not satisfied with the pecuniary gain that they might get out of a settlement.
Right.
So that's good. Slide. I'm going to skip through this. This is about the technical requirements that you have to fill in order to be able to step into the shoes of the claimant and plaintiff. If you have specific questions about that, we'd be glad to answer them, as you know, in many, many words. So if a plaintiff or claimant brings an action under Section 29, because the employer has a right, is subrogated to the claimant's ability or the right to bring an action, the employer or the employer's consent or a judicial approval of the settlement must be obtained. So you cannot settle a third-party action, and that's what we're going to refer to actions under Section 29, unless the carrier or the employer gives consent, or the claimant seeks and obtains judicial approval of a settlement through generally a non-proton order. Slide. And James can tell you about Section 29.5.
29.5 says that you have to get written approval from the insurance carrier or the state insurance fund or the employer. Whoever is the person that holds the lien must provide written consent to settlement. Must be written consent to settlement. It seems really simple, but anyone out there with any experience in this area knows that there is tons and tons and tons of case law that talks about the frequent times, and it happens every year. It goes up to the appellate division. There's always case law in Section 29.5 at the appellate division every year about what happens when somebody doesn't do it or comes up, tries to figure something out some sneaky way around it.
Yeah, or they accept an email from the carrier which suggests that if certain criteria are met, that they might be willing to consent, and they'll take that as consent, or they'll try to say that the verbal consent was given, but that doesn't suffice.
And not just written, the case law says clear and unambiguous have to be the terms of the consent. So they've talked about almost every clause has case law about it that is involved in a typical consent letter, and every time they start out by saying, these terms have to be clear and unambiguous. So even a suggested consent, a partial consent, an unclear term, it has to clearly say we consent to settlement.
So if plaintiff does not get consent to settlement, all is not lost. They could request judicial approval of a settlement generally in the court in which the action was brought, or if there hasn't been an action yet, in a court of competent jurisdiction, which essentially means a court where the action could be brought if the action was put into suit.
Well, and we should probably just step aside for a second and say the reason that they care is obviously we have a lien and we're going to sue the bejesus out of them if they don't pay it back. But the reason why they probably should care is that if settlement's not obtained or consent's not obtained and the settlement it proceeds, the remedy before workers' comp for that scenario is a finding of settlement without consent, which has long been held to end the comp case. It is essentially a full and final settlement by default. Claimant doesn't get $1 of medical or $1 of further indemnity if they settle a third-party action without consent. Even if that third-party action is worth like 5 cents and the comp claim is worth $500,000, there's no consent, the comp claim is dead.
Absolutely. And just like with the employer's rights to be subrogated to the claimant's cause of action, with respect to the petition that is filed in order to seek judicial approval of settlement, it's highly technical and really requires a lot of information and affidavits that generally, in my experience, plaintiffs don't supply. So it would be our recommendation that you definitely have a defense attorney review a request for non-protunct approval of a settlement before the matter goes to court, because even if you don't necessarily have objections to the amount of the settlement and you think it was reasonable, there could be a likelihood that the plaintiff took too long to seek judicial approval, or that the petition itself is defective.
Right. I mean, there's a reason. I mean, there's a reason why these errors occur, which is because the real subject matter experts on this area, even though it starts to tread into negligence actions and other lawsuits in Supreme Court, are comp attorneys, and errors occur because people don't talk to comp attorneys in advance. The plaintiff's bar could be talking to the claimant's bar and saying, "What do I need to do?" They would be much better suited to explain that than trying to those third-party lawyers trying to figure it out on their own.
In my experience, plaintiffs' lawyers treat comp lawyers like second-class citizens.
Well, it's also shocking that so many insurance defense lawyers go into these actions. I was just in court 2 weeks ago on it, an insurance defense lawyer who really should have known, had absolutely no idea both what was going on and what sort of penalties their client was liable for, given the fact that the lien hadn't been repaid. It was kind of shocking to me. So, So
our advice is, if you do get one of these, certainly it wouldn't be unreasonable for you to contact an insurance defense attorney, but I think you'd be best served by contacting somebody who has experience in workers' compensation defense.
Right. Yeah.
Slide. Now we're going to talk about some general principles in the law which are going to govern aspects of third-party recoveries and how you receive your benefit. So in the law, there is a maxim, which is that for every one injury, there should only be one recovery. So if I fall down and break my leg, I shouldn't be able to both sue party A and get a full recovery for that injury, and then also turn around and sue party B and get another full recovery for that injury.
I mean, this is like old English common law before we even had a legal system, right? This is like Blackstone stuff, right?
Correct.
This is that old, and that's why the Court of Appeals said in like the 60s, and they've repeated it many times, so they haven't had to touch it much, just to say it again, is the lien is inviolable. The lien is what prevents the double recovery. There are technically two recoveries. It's just the claimant can't put both of them in his pocket.
Right. And this the same is true of the credit. So we're going to talk about that in a little more depth in a minute. So just remember, slide, that even though Section 29 allows 2 avenues to make a recovery, as James just pointed out, you can both collect and seek workers' compensation benefits, and you can sue a negligent tortfeasor.
That was a double.
Under Section 29. If you get a recovery on both, there has to be a mechanism in place to prevent that from being a double recovery, because of the maxim that for every 1 injury, there's 1 recovery. And then much of Section 29 is targeted at preventing the plaintiff claimant from receiving a double recovery. So, slide. So the first thing I'd like everybody to, and the reason we're talking about benefits is because we're going to talk about apportioning attorney's fees in a little bit. And so our emphasis at the beginning here is going to be on who benefits from the recovery under Section 29. So we're going to take a look at an example. In our first scenario, the claimant is entitled to $250,000 in comp benefits. And for right now, I don't want anybody to worry about whether or not that's benefits paid in the past, benefits being paid present, or benefits being paid in the future. Just assume for purposes of this example that we know that the claimant's total benefit from comp is going to be $250,000. She brings an action under Section 29 and she gets a recovery of $1 million. So at that point, what we know for sure is that the claimant, as a result of the fact that there was a tortfeasor, has received $750,000 more than she would have received if she had only been entitled to workers' compensation benefits. So in other words, if she had just had comp, she would have had a $250,000 avenue for recovery. But because she was able to sue a third party, a negligent third party, she ended up with a recovery of $1 million, which is $750,000 more than she would have received if she'd only been entitled to workers' compensation. Okay, so if the amount of the recovery is greater than the amount that the person would have received under workers' compensation, then the employee can potentially benefit from the third party recovery. In this example, to the tune of $750,000.
But we know that really the only party who ever always benefits are the attorneys.
Always.
Always.
Slide. Here's another scenario. You want to go through this one?
Oh, I don't like numbers. Okay, I don't have a calculator, but I'm going to do it. So this claimant has a $250,000 comp claim. That's what it's worth, full value. The third party is $75,000. This is a deficiency case, isn't it?
It is.
Yeah, the total amount payable as a result of the work injury is $250,000. This dude only gets $75,000. So if the amount of the recovery of the third party is less, the claimant's entitled to, he doesn't get a benefit because we get all the money.
That's right. So in this instance, the workers' comp claim was worth a lot more than what the third party was worth. But again, for the one injury, the total value can only be $250,000, the value of the comp claim. It's the larger of the two things. The
case I just appeared in front of in Supreme Court was a deficiency case.
Oh, was it?
And when I said the phrase deficiency case, there was like crickets in the room for a minute. As I said, this was a deficiency case. All this money belonged to my client.
And then everybody knew that you knew more than anybody else in the courtroom, and they said, "You win, James."
That's exactly what happened.
Slide.
The most humble.
So it's important for you to know. I need a drink.
I know. No.
What's important for you to know is that the injured employee doesn't always benefit when he or she brings a third-party action. Because, in other words, sometimes the workers' comp claim is worth more than the third-party action.
But that's usually not a function of like the worth of the injury or anything. It's usually a function of when they establish like negligence, like to what degree they were negligent. And then it's usually coverage, right? That's in my experience. It's always been like, they got a $25,000 policy. That's what we're going to take.
Well, it can be, but there are also in, I don't want to call it real law, but in negligence actions, because you can apportion back to previous conditions to a greater degree than you can with a workers' compensation claim.
And the comparative negligence too, right? It's like, because, we have to pay for it no matter how dumb the claimant was and part of the injury. It could be entirely their fault, and we pay for it in comp.
Correct. So those are reasons why a third-party action might settle or might get tried and end up costing or leading to less than what you would get under the comp claim. Slide. So although the injured employee might not always benefit from the recovery in a third-party action, what's important to know is that the employer always has the potential to benefit when there's a recovery obtained under workers' compensation law, section 29. And if you know lawyers don't normally say things like always, but in this situation, if there is a recovery, it's important to know, if there is a recovery, then the employer always has the potential to benefit. So you will either get a lien recovery or a credit or both, unless you waive them. So that's why I said that you have a potential to benefit.
I mean, I guess if they settled it for a small enough amount and there was a large amount of fees and costs, like disbursements and stuff, I mean, I guess the claimant would still collect something, right? I mean, it would be weird to settle a case where the plaintiff collected nothing. I mean, I've heard that tell of firms in Buffalo doing that, like settling a case and there's no recovery for the plaintiff.
Where only costs and
fees.
You're getting in the weeds.
Yeah, okay, deep in the weeds. Yeah. Moving on.
All right. So as we said, workers' comp law, section 29, prevents double recoveries because for every one injury, there should be one recovery. Now, at the time of a settlement, there are two different types of benefits which have to be considered to ensure that a claimant doesn't get a double recovery. Benefits which have been already paid in the past at the time of the recovery, is a lien, and benefits which will not have to be paid in the future, which is referred to as
credit
or
holiday
or
I don't know, what's the third thing?
Offset.
Oh, offset? I've never called it an offset. It was just like I was taught the shorthand. It was always holiday. And that makes
None of those words are actually in the statute. So
I know.
Well, don't look for them in section 29.
Holiday is definitely the farthest one from the statute, but it makes its way into comp decisions all the time.
And it sounds really happy.
Holiday. We got a holiday. Yeah. We're celebrating a holiday. Yeah.
But we're from Europe and we're going on holiday.
We're going on holiday. There's a great movie called The Holiday. It's a Christmas movie. My wife loves it.
Okay, so let's take a look at another scenario. Slide. I'm actually not ready to look at another scenario. Apparently, we need to talk about past benefits and lien rights a little bit more. So we said there are two ways that we're going to prevent a double recovery. We have to look at benefits already paid, benefits that aren't going to be paid. And frequently, people get confused in this area of the law because they refer to benefits which aren't going to be paid in the future as the carrier's lien. You will never do that again because you're listening to this great TV show right now. And so you now know more than 95% of all of the attorneys in this state when it comes to section 29.
Right. There's no such thing as like a future lien.
There's no such thing. It is a credit or a holiday or an offset. So if you're talking about a lien, you should only be talking about the recovery of benefits paid in the past at the time of the recovery. Right? And so to address prevent a double recovery at the time that the claimant gets their settlement, they have to repay all of the comp benefits that have already been paid. By doing that, there is no double recovery. So let's take a look at a scenario. Oh, I guess I'm
skip the slide. Just skip it. There's another one. What is that one?
Back it up. We can't skip it yet.
Oh.
So let's talk about now the second kind of benefit that the carrier or the employer can get from the third party, and the second mechanism by which we prevent a double recovery, and that's credit rights. So in the future, the carrier is not going to have to pay for benefits for whatever the claimant puts in their pocket as a result of a recovery. And that's how we prevent a double recovery for benefits which haven't been paid yet at the time of the settlement. So to prevent a double recovery for past benefits, the carrier gets a recovery of their lien. To prevent double recovery for future benefits, the carrier doesn't have to make payment of future benefits until such time that the amount of future benefits exceeds what the claimant recovered on their third-party action, which is also known as a deficiency case. All right.
At that time.
Right.
Yeah.
So usually at the time of a recovery, you don't have just lien rights to worry about. You don't have just credit rights to worry about. Side. You have both lien and credit rights that you're concerned with at the time of a recovery. So not only do you, when you're being asked to consent, want to address how you're going to be repaid for the benefits you've already paid, you also want to ensure that you're preserving your right to not have to pay benefits in the future if the claimant has recovered anything at all as a result of the third-party action.
And it sounds simple. I know this might be jumping into the weeds. I don't know how far we're going to get through the presentation with the time remaining, but I want to point out right here is that there is a bunch of case law, including some really important cases like the Terra Nova case that ended up at the Court of Appeals 2 years ago, that talk about how you take your credit. Because if you aren't explicitly clear in your agreement with the claimant's third-party counsel about how the credit is going to be eaten up or diminished by future benefit awards, it will be interpreted in the way that screws you the most.
It is a little bit in the weeds, but you're absolutely right, James. It's very important. And
there's just no way. There's no way to get out of this without having like a really experienced attorney talking about every little thing you do on these cases.
You definitely want to be very thoughtful about the language that you use to preserve your third-party credit rights, because there's a lot of interplay with how the credit could be reduced because of an ongoing burdens obligation that you and I know about, and we'll talk hopefully a little bit about as we progress here.
Right.
But it could definitely either accelerate or decelerate how quickly your lien gets used up, which obviously we want to decelerate that process so that your credit lasts longer.
Yep.
Let's take a look at an example. Slide. Oh, finally, I got to an example. All right, so example one, we're going to look at both lien and credit rights. At the time of $1 million settlement, you, the carrier or the employer, has paid $100,000 in medical and lost wages. Okay, let's assume that the claimant's future benefits after the recovery up to the date of death are valued at $150,000.
This is a Kelly case.
Don't talk about whether it's speculative or not. We're just going to.
It's a Kelly case.
Yeah, we're.
It's liquidated.
Well, it's not. No, it's not a Kelly case because it's. No, it's just not. It's nothing.
It's nothing.
I'm asking you to suspend your disbelief.
Okay, suspended.
All right, great. So again, $1 million settlement, $100,000 in payments and comp at the time of the recovery, and we know without speculating that the future benefits that would be due to the claimant on the comp case are $150,000.
So in the absence of cost sharing for cost of attorneys, we have a $100,000 lien for the past benefits that we paid, and we have a $150,000 credit or holiday against the future compensation that would be paid. So essentially the comp claim is dead, right?
Right, because
there's no cost of litigation contribution, which we'll talk about later, so the comp claim's dead.
Right. So in that situation, as James just said, the carrier gets back $100,000. They get to exercise their full credit of $150,000, however that ends up happening.
It subsumes all future benefits. The
claimant's total benefit from the third party is $750,000. Now I want you to think of total benefit from the third party as the difference between what they would have gotten in comp, had comp been their only avenue for recovery, $250,000, and the total recovery from the third party. So in other words, the claimant got $750,000 more as a result of this recovery than he would have had he been limited to his compensation benefit.
Because that assumes that of the $150,000 in future benefits that haven't accrued and haven't been paid yet, the claimant's going to pay those out of the cash they put in their pocket at the time of the settlement.
Correct.
Because we're exercising a holiday against it. We're saying we're not paying, you pay out of your own pocket.
Correct. And the carrier's benefit in this example is $250,000. The carrier got repaid $100,000 at the time of the settlement because they recovered their lien.
Yep.
They're relieved of having to pay $150,000 in future benefits to the claimant after the recovery. And so the carrier's benefit in this situation is $250,000, which means essentially that the carrier, even though there was a workers' compensation claim, ends up not having to really pay anything as a result of this because there was a tort feasor.
Yeah, this is a zero-sum game for them. They came out whole. I mean, they're not going to get recovered for. They're not going to recover for the costs that they spend in maintaining the claim
we'll get into
or paying
some
attorneys
more of
and
those
stuff.
subtleties in a second.
Yeah, but it was essentially a $0 claim for them.
Right. Slide. Example 2, lien and credit rights. At the time of a $75,000 settlement, the carrier has already paid $100,000 in benefit. What's going to happen?
Well, that means that the entire proceeds of the settlement are going to get repaid to the employer.
Slide.
Money back.
So the value from the third party is less than the total amount of the workers' compensation claim. So the carrier is going to recover the entire $75,000, as James just mentioned, through lien repayment. There's no credit because the claimant didn't get anything.
Right.
And so the claimant's net benefit from the third party is $0.
Awesome.
However, the carrier's benefit from the third party is $75,000 because you got the whole recovery from the tortfeasor for $75,000. You still have to pay the rest of the comp benefit, but you had $75,000 that you wouldn't have otherwise had to pay.
Good, but not awesome for the carrier. You'd want to get all your money back, but if you get what you take, sometimes you get what you can.
It's definitely, if there is a tortfeasor that you can find on a workers' comp claim, but you want to find them, even if the claimant doesn't. With our system in New York and in the United States, with contingent fee arrangements, it's if there's an action,
if there's a pocket,
an attorney will find it. But
if there's a pocket and there's an action, somebody's going to be putting their hand into it. Yep.
Slide. Okay, so, and again, remember, the claimant and the carrier can benefit from the third party, but the carrier always has the potential, stands to benefit from a recovery, whereas the claimant may not benefit.
Right, because you have the two potential uses of it, either a lien recovery or a holiday.
Right. Slide. So now we come on to the dreaded question of who's paying the attorney's fees, which is where most of the fights in this area of the law arise from. Which makes
everyone,
sense.
Everyone's paying the attorneys.
Right.
It's not even us. It's not the attorneys that I'd want to have paid. It's these other attorneys.
I know.
Jeez, what the hell?
So the question is, when you're trying to determine who's paying for the attorney's fees, is, well, who benefited from the work the attorneys did?
And I'm going to bet that you're going to give us an example that shows the pro rata payment of attorney's fees based on the ratio of recovery.
It might be in the cards. First, we're going to talk about, next slide, the actual section of the statute which gives the plaintiff a right to apportion the costs and attorney's fees between the carrier and the employer who can, you're about to yawn, the carrier and the employer who can benefit from the third party and the plaintiff.
Talking about large firms that have jingles on television recovering their fees and having to be an expert in it just it bores me because it's like, why do we have to be experts in their money? You know what I mean? It's ridiculous. And it's not even their money. They're just, I don't know. It's our client's money. That's what always gets me mad. It really is our client's money. We're the ones footing the bill. You know what I mean?
Well, it's really for the third party recovery, it's the carrier and whoever's paying the settlement.
No, but I mean, we're paying in the first instance, though. Like, we're the ones that are making this all.
It does seem like it's a fee and a fee.
It is a fee and a fee.
Yeah. All right. So what we need to do, slide, in order to equitably apportion the costs and the attorney's fees between the claimant and the carrier, the two parties who can benefit from the third party, is determine the party's share of the cost by determining their benefits. And that is found in section 29. Slide. So let's take a look at an example.
Struth!
So again, we have $1 million recovery from a third party, a section 29 action. And $250,000 is payable in comp. Again, don't worry yourself about whether it was paid in the past or whether it's going to be paid in the future. We just happen to know that the amount paid in comp is $250,000.
This is a Kelly case, right?
$1 million. Stop it with the Kelly case. The total cost for obtaining that recovery, that $1 million recovery, is generally, it hovers around 1/3 because most contingent fee arrangements in New York are 1/3, 33% of the recovery. So the costs in $1 million recovery, the attorney's fees are going to be approximately $333,333. You get it. The share, the claimant's benefit, remember, is the amount that he pockets over and above what he otherwise would have received in comp. So $1 million minus $250,000. The claimant's benefit in this situation is $750,000. The carrier or the employer's benefit is $250,000 because they're either going to get that back in a lien repayment or through a credit.
Right.
Out of that $1 million. And so the carrier's benefit is $250,000. So to figure out their equitable costs, you figure out their benefit, and then you apply the same contingent fee percentage to whatever their benefit is.
And it works out, since the claimant gets 2/3 of the benefit, the claimant covers 2/3 of the attorney's fees.
It's beautiful how it all matches up. It really is.
It's science.
It's math.
Oh, math.
I like math.
It's math. I don't have my calculator, so I can't help you.
Let's take a look at the deficiency kind of cases that we've been looking at throughout the presentation. So example number 4, we have a $75,000 recovery, and we know that the comp case is $250,000. So it's deficiency because the third party is deficient compared to the comp case. So out of the $75,000 recovery, the cost, the attorney's fees of that $75,000 recovery, again, approximately 1/3 because of the contingent fee arrangement. And so the carrier is the one who's going to benefit from the entire $75,000 recovery.
Yeah.
The claimant's benefit is 0. So not surprisingly, the claimant's share of costs for a $75,000 recovery when they're not getting anything out of it is 0. And the carrier or the employer has to bear the entire cost.
Gag me. it's like here we're going
to should tell me how you really feel.
Well, it's basically I'm going to pay your fees so you can put a few more commercials on TV and sue me again. Some other case.
Slide.
Great.
What kind of time are we working on here?
Oh,
these poor people only have a little bit more.
Okay. How do the costs get? Oh, here I'm going to take this one because I'm going to short circuit it. How do the costs get paid? Well, the tortfeasor's carrier or the tortfeasor or however they have that cash, they turn that over to claimant's plaintiff's counsel. He puts it all in escrow, and instead of actually money changing hands back and forth, you're just going to take offsets. So say instead of collecting X, they're going to turn over a certain amount to the other party. So it's not like we're exchanging checks. You know, like you give me $250 and then I pay you back your $83,000 attorney's fees. We're just offsetting things.
So yeah, nobody needs us because that was basically that's just how it's done.
No, but I mean we're shepherding the process.
Okay. So how do the costs get paid? Well, it depends. Like if it's a lien, then it's easy because you just reduce your lien by whatever
the equitable
whatever the amount of the lien is.
Right.
You do it or not the lien, but whatever the equitable share is, like James said. But if it's a credit, how do the costs get paid for the credit? That's the question that the courts faced in slide.
Kelly, fresh money.
Kelly versus the state insurance fund.
Is this where I get to say fresh money and not be wrong?
Correct.
Oh, this is the one time all year I get to say fresh money and not be wrong.
So Kelly versus State Insurance Fund took a look at, well, it's an easy thing to figure out how the carrier pays for the costs and the fees associated with the lien recovery. You just reduce it by the third or whatever the contingent fee arrangement is. But how does the carrier pay for the benefit they're going to receive from the holiday or the credit or the offset?
And this is where you have a relatively small comp lien, but you have a third-party recovery that's gigantic usually, and that means the attorney's fee is huge. The attorney's fee itself might actually exceed the comp lien.
And there's a big, the last component of that is that there has to be a huge benefit to the carrier in the future. So,
which is the claimant's pocket money.
Well, right. Sometimes that pocket money isn't really a benefit because the claimant has a schedule or they had a very minor injury, they've returned to work. But there's a real potential for a future benefit to the carrier as a result of that.
Right.
So what Kelly versus the State Insurance Fund is addressed not only the fact that in order to pay for the lien recovery, the carrier reduces its lien by whatever the percent cost of litigation is, but it also took a look at how the carrier should have to pay for the future benefit. And Kelly versus State Insurance Fund involved a death claim with a widow, and death benefits under the comp statute are limited by the life of the widow. There's a specific procedure for doing a calculation for those benefits into the aggregate trust fund. And so what the court in Kelly found with respect to the future death benefits was that they were not speculative, because the board itself, the statute itself, had a mechanism for valuing those future benefits. And because the amount of the benefit that the carrier and employer was going to receive in the future could be ascertained without speculation.
Liquidated, if you will.
Liquidated, certainly. The carrier was required to pay the costs associated with that future benefit at the time of the recovery. And because the lien in Kelly was insufficient to cover the payment for the attorney's fees associated with the future benefit, the carrier in Kelly had to pay additional money to the claimant's widow. Well, the claimant was the widow at the time of the recovery.
it's like there's just sometimes where I hate attorneys, and just leave
It's a
it
very good
leave it
argument.
to New York, first the state of New York, and then attorneys in the state of New York to be like, oh yeah,
Slide.
you have to contribute to future attorneys' fees costs in this case, even though
Yeah.
it's absurd. It really is.
Yeah, when you really think about it, because the net recovery is only against, it's the attorney's fees already carved
Can
out,
you
so the
imagine?
credit is only limited to the amount of, like, already less the attorney's fees, so that'll really.
Can you imagine
think about that?
But I mean, can you imagine the poor
But let's
bastard
not.
sitting at a table writing a check for fresh money? I mean, I would probably
Well,
have a stroke.
The good thing is that when they wrote that check for the fresh money, they essentially bought the end of the comp case, like
Right.
you were saying earlier. So I mean, they pay for their future credit, which is going to vastly exceed the
Subsume,
amount
yeah.
the value of their future credit or their liability. So they prepay essentially for that benefit. So let's take a look at Kelly example. Next slide. $100,000 recovery. We have a $100,000 lien, and we can determine the future value, the value of the future compensation that the carrier is not going to have to pay is $150,000.
Right. So we got a $250,000 benefit to the carrier total, which is future comp offset and the lien. But the claimant's putting $750 in her pocket. So the proportionate share, right, is going to be a third and two-thirds, or a third and two-thirds, right? So we have to contribute a third to the attorney's fee, which is a third of the 333, which is whatever one.
Why don't we
something.
turn the slide, and everything he just said is on the next slide, because that's exactly right.
Oh my
Right?
God!
So this is essentially, he's getting a clap.
I did it without the calculator too.
So this was our example from a little bit ago. So we know that the claimant's benefit here is $750,000. The carrier's share is $250,000. The claimant's share of the cost is going to be a third of the $750, $250. The claimant's net benefit is $500. The carrier's share of the litigation cost is going to be one third of the $250,000, and then the carrier's net benefit is going to be $166,667. So the lien of $150,000 is going to be reduced by $83,000, because that's the carrier's share of the cost for both its lien recovery, $33,000, and $50,000 for its future benefit of $150,000. So the carrier is only going to recover $16,667 out of their lien, and they'll get a full $150,000 credit, and they should never have to pay on this case again.
But you can see this example just demonstrates the math that the larger the recovery and the larger the attorney's fees, this was close to being a fresh money case.
This is a fresh money
Oh,
case.
yeah. But they didn't make a second payment. They just took a extra
I'm
lien
sorry,
reduction.
you're right.
Yeah, so that if we doubled let's say it was $2 million recovery and you double the attorney's fees, all of a sudden it goes from being, an $83,000 reduction to a $160,000 reduction, and that's when you start cutting a check.
Why don't we take a look at a fresh money case? Example 6 is next. You want to go through it?
All right, a $1.2 million recovery. We have a $100,000 lien, so it's already not looking good. We're going to have to cut that terrible check. $500,000 of future comp. So the carrier's total benefit in this case is $600,000, which is exactly one half of the recovery. The total costs are $400,000. So let's skip to the next slide, Najee. So the claimant's benefit is half too, right? Because we've got the attorney's fees. That's the money that the claimant's going to put in their pocket after the attorney's fees are paid out of it. That's so now the share of cost for the claimant is $200,000. The carrier's total benefit is $600,000 because we have the $500,000 in future comp that we're not going to have to pay, and the $100,000 that we're getting cash back now. So their share of the cost is $200,000. So the lien is entirely gone now, right? But the carrier has to pay fresh money of $100,000 to contribute to the percentage cost of litigation as associated with the $500,000 worth of future comp that they're getting out of paying. Future comp, that's one of our clients too. But there's no fresh money for them. Carrier does not have to pay $500,000 in future comp because they've contributed to their cost of litigation that's associated with that. The claimant's going to get $900,000 cash at the time of recovery, some of it coming from the third party, from the tortfeasor, and actually some of it being paid by the comp carrier. That's somebody writing that check.
I don't want this to sound patronizing, but I'm super proud of you.
Slide. Tortfeasor. If you guys aren't all drunk now.
All right, so that was Kelly. All right. Now, Burns versus Variale was a 2007 case in which the carrier and special funds primarily argued that sometimes the future benefit to the carrier is so speculative that it would be unfair to try and assess what the costs, what the carrier's share of the attorney's fees should be at the time of the recovery.
Into the future.
Into the future, right. So obviously the lien, you always know what the lien is at the time of the recovery. In Burns, the claimant had been classified with having a permanent partial disability. And actually, after the judge ordered a fresh money payment at in the motion court, he was found to be unattached to the labor market. So
somebody told me, did he die at some point too? No. Okay.
So it was a great set of facts because the argument was that the judge shouldn't base a determination as to what the carrier's share of the costs was going to be on a future benefit because it was speculative. And then shortly after, the judge said, no, you have to cough up all this money because I find that the future benefit is not speculative. The claimant was found unattached to the labor market, which was exactly what one of our points was in arguing that the future benefit was speculative. So Burns versus Variale addressed the situation of what do you do if the future benefit to the carrier is speculative? How do you assess the cost that the carrier should have to pay when they enjoy that benefit? Slide. What the court in Burns held was that if it's speculative, you cannot determine what the carrier should have to pay for the future benefit at the time of the recovery. But that doesn't mean that the carrier gets off scot-free and doesn't have to pay for the future benefit. What it means is that once the future benefit is known because the carrier starts to exercise its credit, then at that time you can require the carrier to pay for that benefit.
Is this pay as you go?
It is. So for every dollar that the carrier is relieved of paying and they actually receive the benefit, they pay the attorney's fee associated with that dollar benefit on a pay-as-you-go kind of basis. And there are a couple of ways that that can be worked out as well. Slide. Let's look at an example. Nice. So, again, we have $1 million recovery. I mean, you got to admit these plaintiff's attorneys are pretty good.
Yeah, can you imagine how many commercials you can buy with $333,333.33?
Not even one during the Super Bowl.
Oh, really? Is that how much they are?
They're like $2 million.
Oh, man.
So you have $1 million recovery, a $100,000 lien at the time of the recovery, and it's speculative to try and determine the future compensation that the carrier is relieved of paying. But we do know at the time of the recovery that the costs are, and when I say costs, I mean both fees and disbursements. We know that the costs are approximately $333,000. Slide. Go ahead.
Oh, yeah, I was going to say, so the known benefit, so the carrier is going to get their $100,000 lien back. That's the first thing.
Reduced.
Well, the first money that comes back, right? The first money that comes out is the $333,000 in attorney's fees, right? Those are already gone. They get that $1 million check. The first thing that gets paid is those attorney's fees. So there's $666,000 left. Mm-hmm. Then the carrier's got a $100,000 lien, which we're going to have to reduce by the cost of litigation. So we're going to get a $66,000 lien. Just lob a third off of it. So then so we've got $666,666 in the escrow account. Then they're going to cut us a check for $66,667. So now there's $600,000 left to pay over to the claimant. That's how I think about it. It's like, balancing that escrow account, right? So the claimant's going to get $600,000 put in his pocket. Well, what do we get in exchange for that? $600,000 credit. But we also have a cost of litigation for future benefits that hasn't been satified yet.
Correct.
Right, it's just out there
because
in the
we haven't
ether.
received the benefit yet.
Right, because we haven't gotten it yet.
Mm-hmm.
So that's where we get the cost of litigation. We set the COL percentage when we make those findings in comp or we make those findings in a consent letter, which says that we have to pay 33 cents on every dollar of comp that's awarded in the future, be it a medical benefit or a lost wage benefit. Yep. And this is where you have to be careful because the case law about taking your credit and how your credit gets subsumed. Because if you write the thing wrong, you're going to end up having your credit subsumed not just by the benefit that you've received by being excused from making a payment, but also by the payment you made.
Which is crazy.
Which is, again, how does the court come up with that? Oh, I forgot. It's in New York. Fast-talking attorneys and their judges in New York.
Okay.
That's it.
So I'd like to skip the next slide.
Yeah, because we're like almost out of time.
We are.
We've been burning it up here.
We're going to have to do a practice tip. The moral of the story is that if at the time of consent to settlement, you can negotiate a global settlement, we think it's a great time to do it.
Right, because usually you're not going to pay any money to close the comp claim. You're usually just going to
You're usually going to get some money back.
Yeah, so you can
on your lien, depending upon the size of your lien.
Yeah, you can post a recovery against your reserves and close the file.
Right, so you get some money back and you're done.
Right.
Yeah, it's a great time. If the claimant's already been classified, that's about our ATF deposits.
Yeah, you need
practice
ATF.
tips in general. Yes, you have to get the consent of the ATF if there's been a deposit, and you should get special fund groups consent if Section 15(8) has been established.
Yeah, 2018 and 2019 appellate division cases on point. You have to ask their permission, but it's okay for the courts to force them to do it on pro-tonk. They tried to have their cake and eat it too. They tried to say you have to get our consent, but you can't compel us in court because the statute isn't written in such a way. It didn't go both. You can't have your cake and eat it too. Yeah, you have to get their consent, but they're just subject to an order enforcing consent under non-pro-tonk under Section 29.5 like anyone else.
So we're going to do last thing before we leave, which I think will be a good way to end, will be to look at an example of doing a global settlement.
You've been talking about this, the return to Kelly. This is your return to Kelly. This is like return to the Jedi.
No, I skipped that slide.
Oh, okay, good. Okay, I was like, because it's post-2007 claim. All right.
Yes. Because of the caps, it makes our future benefit less speculative, but that's for another day. So what we want to do right now is just take a look at an example on a post-2007 claim with a settlement and a Burns obligation. So we have an average weekly wage of $900 and a date of accident of January 1st of 2010, which means that the max rate at that time is $600. We get a $1.2 million proposed third-party recovery. Looking good. We have a $300,000 lien. And the parties agree that it looks like the claimant's going to be classified with a PPD and LWEC of 80%, entitling her to $450 a week for 425 weeks. So we have a future benefit that's pretty well known.
I don't have my calculator, and there's a lot of math.
I did the math on the next page.
Glazed over. Slide. Hurry up. Okay.
All right. So our Burns obligation, which is the pay as you go, pay as your benefit as you receive it, means that we should have to pay $150 a week for another 425 weeks, because we're paying $150 out of that $450 a week obligation as a result of the PPD finding.
The Burns contribution against indemnity.
It's 1/3 of the $450 per week. All right, we have to pay that for another 425 weeks, and that's equal to $63,750. Okay, there's a $1.2 million recovery proposed, which comes in on June 1st of 2014. We have a $200,000 recoverable lien. Remember, our total lien was $300,000, and we reduced that by the percent cost of litigation, which is 1/3 for a contingent fee arrangement of 1/3 without any disbursements. And so our recoverable lien is $200,000. So right now, out of that $1.2 million settlement, we're looking at pocketing $200,000. Okay, but what we could do is we could agree to reduce our $200,000 recoverable lien by our Burns obligation of $63,750 and recover $136,250 out of our $300,000 lien in order to get a full and final Section 32 agreement.
Right. And this would be the case where you would collect a recovery against your reserve and close your file.
Right. So this is the way to do it. And plus, the claimant is in a position where they know they're going to have to deal with having a 1/3 payment ongoing and potentially have to come in and seek to get reimbursed on their medical expenses because they can get reimbursed on their medical expenses.
But your consent letter was written by a really competent counsel who said they had to pay the whole thing up front at fee schedule first, and then our obligation to repay it is subject to any objection that we might lodge under the comp law, and that we're only obligated to reimburse 1/3 of the fee schedule. So it's a pain in the ass for these people to do it. Because
it is. They want to settle. They do.
How many claimants do you have on your books that you think could manage that?
Yeah, it's a good thing for everybody if you can do it at the time of the settlement.
It absolutely is. And the thing is that the future value of medical has declines way more than the future value of indemnity because of all those complications and the fact that you have this large holiday. You might have a Burns obligation going forward, but it's worth a lot less than the Burns obligation against indemnity. And practice point, never put a case to bed on a consent letter with a CCP in the comp case.
No.
Because there are appellate division cases in the last 2 years where that was done in the mid-2000s, and all of a sudden giant credits, $500,000, $1 million credits are gone because it went away on a CCP at like $400 PPD, an old $400 rate case, and all of a sudden they reopen the file and say, oh, it's all gone, it's time to start paying again on the comp case. And the carrier's attorney comes in and goes, but you weren't attached to the labor market, or it wasn't a PPD, but they just put it to bed on a TP, and there was no medical for 15 years, and the court says,
too bad,
it's
so sad.
Too late. I'm updating awards to date, 400 TP.
Your credit's gone and you have to pick up payments.
Yeah. Oh, and by the way, the credit expired 2 years ago.
Yeah, so you have to do a retroactive.
And you have a retroactive payment. Don't do that.
Yeah.
If you're gonna consent, you have to put in the consent letter and then get it translated in the comp case that you're reserving all your defenses and that you're keeping the claimant honest and making them subject to their obligations.
Frankly,
under
I would
normal
continue to
comp claim.
litigate those files too. I would not.
Because
sleep on your laurels.
Because
I have the same position when you take an appeal.
Right. If you can settle if you can litigate the comp claim and get them suspended, even when you're on a holiday, it's a worthwhile endeavor because it's you're extending the time of the holiday to the point where it devalues the case.
Yes.
The farther away that you make the light at the end of the tunnel for them, the more likely you are going to be able to come out advantageous on the file.
Absolutely. Throw up the impediments and frequently they'll just go away.
It's not even an impediment. Just make them do their
$1.2 million and they
yes, because
rub it on them. And
anyone who watches South Park, if you take cash and turn it into a slurry, you can rub it on your injured parts of your body and it heals them.
And on that note, tortfeasor. And we are going to wrap. We do have additional slides that we're not going to torture you with any further.
Yeah, this one
if
just...
If you'd like the full presentation, let us know. We'd be glad to provide it to you. And as always, I believe we'll have a recording of this presentation on our website after today, once we're able to get it on the site.
www.getmad.today.
That's right. That's us.
So we'll take your questions now if there are any.
Oh,
if you're
no, I don't think we're set
questions?
up for that.
Oh, no questions?
So,
they're
but
not
if you do
awake
have
anyway.
questions,
They
everybody left like
were
half
gone.
an hour ago. Anyway.
Yeah, if you have questions, email us.
Yeah, you know how to find us. So again, thanks for tuning in. And next month, James will be doing, the plan is that James is going to do his fabulous end of the year case law presentation where he's going to review all the important appellate division decisions from the entire year. He's been working on it the entire year. I've always been super impressed with the diligence. I used to do mine during the last 2 weeks of December and it ruined many holidays for me.
Well, there's going to be a lot of writing soon. At least I've read all the cases already.
That's very great.
We're okay. It's just going to be a lot of writing and figuring out what's important.
So stay tuned next month for that episode. I don't know who his friend will be, but I'm sure he'll be able to impress somebody into service from around here.
Works for me.
Okay. Thanks, everybody.
Bye.
Things keep changing and never for the best, at least not for you. Rearranging rules that we cannot contest. What can you do? Don't go crazy when the judge says your claimant had a good day, when things look hazy, 'cause there's nothing left of 25A. Don't get angry, get mad today. We're gonna help you through it all the way. It's never easy, it's never fair. You can't find any reason anywhere. And if you're ever at your wit's end, we are here for you, our friends. Don't go crazy when the judge says your claimant had a good day, when things look hazy, 'cause there's nothing left of 25A. Don't get angry, get mad today. We're gonna help you through it all, 'cause you, my friends, are beautiful. We're gonna get you through